Karen Reed was accused in the January 2022 death of her boyfriend, Boston police officer John O'Keefe. Prosecutors charged her with murder, claiming she ran him over with her SUV on purpose. Jury deliberations began on June 25, 2024. After approximately 25 hours over several days, the jury reported being unable to reach a unanimous verdict. They sent out one note on Friday, then two more notes the following Monday informing Judge Cannoni, who then declared a mistrial. Following the mistrial, Reed's attorneys filed a motion to dismiss counts 1 and 3 of the indictment, charging her with second-degree murder and leaving the scene of an accident. They claimed that several jurors had reached out, indicating they had found Reed not guilty on these specific counts. On August 23, 2024, Judge Cannoni denied the motion to dismiss, and her decision was upheld by the appellate court. Neither Judge Cannoni nor the appellate court wanted to hear from the jury. They did not want to know if the jury mistakenly thought they had to reach a verdict on all 3 counts. So unlike the Massachusetts judicial system, we want to hear from the jury. And tonight, we will, with a live interview with one of the jurors from the Karen Reed trial to try to get a full understanding of what happened in that jury room and to figure out if Karen Reed actually convinced them she was not guilty of murder.
I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. Great to have you aboard. This is going to be a huge hour. Don't go anywhere. We're going to learn things in the next hour that we've been wondering about for months now. So let's begin here. The concept of double jeopardy in this country. You cannot be tried twice for the same crime, meaning you go to trial, you're found not guilty, they don't get another chance to prosecute you. All right? It's fundamental to our constitutional rights. Now, Karen Reed believes that she is being tried twice for the same crime. And she's really upset about it. The defense has been fighting about this because they believe the jury in her first trial came to an agreement on 2 of the counts of the indictment that she was in fact not guilty. That the jury came together and all believed the same thing, that she was not guilty. But she's being tried for all 3 counts. That trial is scheduled for April 1st now. Now, the defense didn't just sit back and let it happen. They filed a motion before Judge Cannoni, who denied the ability of them to get some form of relief. What they wanted to do was bring back the jury. They appealed it all the way up in the Massachusetts Supreme Court. Appellate court said no. No, don't bring back the jury. We don't want to hear from them. There is zero interest from the judicial system in Massachusetts about whether or not a jury agreed that someone was not guilty of murder, but didn't quite understand some of the instructions. They have no curiosity about what happened, how it happened inside that jury room, which to me is shocking. Because if there's an allegation of some racial bias, they're very concerned, and they will bring the jury back. That's the law in Massachusetts. But if someone is found not guilty or potentially not guilty by a jury, no curiosity. Well, I have a lot of curiosity. I want to know what happened. And tonight we will. Joining me, a juror from the first Karen Reed trial, joining us live tonight from Massachusetts, Ronald Estanislao. Ronnie, I know we've got about a 1.5 second delay here, so thank you so much for joining us tonight. We really appreciate it.
Thank you for having me.
Let me start right with the headline. I'm going to get right into it, Ronnie. Did all 12 of you inside that jury room agree that Karen Reed was not guilty of murder? Count 1 in that indictment.
Correct.
Okay, now let's roll up our sleeves a little bit. How did you vote? Was there Was there a raising of the hands? Was there someone writing down what your vote was? Was it a secret ballot? How do you know, and how was the process that all 12 agreed that she was not guilty of murder, count one?
So we all raised our hands in terms of a vote, and we voted on that first count that we all agreed not guilty. Unfortunately, at that time, we did not fill out any of the paperwork there, nor sign it. So we were under the understanding that each charge could not be treated separately. And so we continued to deliberate, despite the fact that we had agreed on 2 of the counts as not guilty.
And the second count was count 3, and the same process where I guess the foreperson is asking for a vote and everyone raised their hands?
And everybody agreed not guilty for those 2 charges. That's correct.
Was there, now you mentioned that you didn't fill out paperwork. Was there any discussion about should we check the box on the verdict slip?
So we didn't check the box on the verdict slip because we were still deliberating on the second charge of involuntary manslaughter, and that continued with deliberation. We did send out notes asking for clarification, but unfortunately we did not ask the question at the time, should we treat each charge individually and separately?
So explain to us why the presumption was that you had to come to a conclusion on all 3. Was there any debate among the jurors about whether or not we have to agree on all 3 counts, or it can be just 1 count, or it can be 2 counts? Was there any discussion or debate amongst the 12 of you about what the rules were when it was time to fill out the verdict slip and determine and let everyone know where you were in these deliberations?
One of the big things that happened was we all agreed and voted, and we kind of not came back to any of those charges. We never revisited them because we had already voted on them. And then we kept on debating on that second charge. And because we kept on debating on that second charge and deliberating, that kind of got us caught off guard at the end in terms of how to respond to that and whether to ask. There was a couple of us who did clearly indicate that maybe we should ask about treating each charge independently, but the majority overruled, and essentially we were left to believe that it needed to be all or nothing.
See, that's interesting. See, that's fascinating. That's something I would think the folks in Massachusetts would be interested in, is that now you're talking about there's debate about the rules within the jury. See, I look at that's the fault of the system, not informing you ahead of time about these things. So let's go through, because you all sent out notes. I want to put up the first one that was sent out. I believe this was the one on Friday. Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all of the evidence, we have been unable to reach a unanimous verdict. So that first note from Friday, which I believe was actually the second note that you had sent out, what was the status? At that point, had you already finished on 1 and 3?
To my understanding, on Friday, we had already finished on 1 and 3, and we were stuck on that second charge.
So when you all sent that note to the judge, what type of response were you expecting? Did you have any expectations about what would happen after you sent this note to the judge?
The expectation was she probably is going to send us back to continue to deliberate given the circumstances. So that's where it stood.
Okay, and I always wonder about that, right? Because I cover trials for a living. I know the judge is going to send you back, but I never know what, folks who don't watch trials all the time like I do, or have practiced law, if they expected that. But those were your expectations that, listen, we're stuck, but we know we're not done here, so we're going to have some more work to do. Let's get to the second note. So this is now, that was Friday. Come back on Monday. I think this is Monday around 11 in the morning or so. The second note, or it's actually the third jury note, but the second deadlock note. Judge Cannoni, despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. At that point, sending that note, what were your expectations and the expectations of your fellow jurors about what's going to happen after you send this note out?
I think at that point we knew it was an impasse because we were stuck. We continued to deliberate, but despite continuous deliberation, as clearly indicated in that note, there were beliefs that were not going to be changed. And as a direct result, we could not find essentially a decision that would be unanimous. And therefore, it would be a futile exercise in terms of, and that's the unfortunate thing, is it wasn't clear that that was only on one charge. It clearly is indicated by all those notes. It seems like we were in deliberation and we were in an impasse on all three charges, but that was not the case. And unfortunately, we never asked that question to treat it as three separate charges independently of each other.
So when you send this note, were you expecting that this was going to be the end of the case? That everyone would be going home after this? Were you expecting anything else to happen, any other sort of response from the lawyers, from the judge, from anyone after sending this note out?
In my mind, no. I believe that that was it. We were going to be done, and it would be a decision from there that it would be a mistrial. But that was in my mind. I don't know, and I cannot speak for the other jurors.
Absolutely. And again, thank you so much for joining us. The folks who watched the trial, invested in it, and are very confused by all of this. This is really opening up a lot of eyes. Let's take a look at the final note. So this is the one later on that same day, on Monday. The final note. We continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe the evidence surpasses the burden of proof establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. Now, a lot of people have focused in on two words that were written twice in that note: the charges, the charges. Everyone who's looking at that is saying, well, they were talking about the charges. And there's three charges in this case: count one, count two, count three. So why was it written the elements of the charges? What was that supposed to represent and mean in that note?
I think during the time frame, it was still very clear to us, or at least the majority, that it had to be all or nothing. Again, not treated independently of each other, and hence the verbiage that was utilized in those notes indicating that it should be charges, because again, we as the jury were treating it as such, that it had to be all or nothing for all three charges, not to be treated independently of each other.
I get it. I get the mindset. All or nothing, the charges are the charges. If we don't come to a conclusion on all three, then we're having trouble dealing with the charges, as opposed to saying the charge or count two. Let me ask you this. As you all were focusing in on that second count, what was the debate there? What were you looking at, and how close were you? What charge were you considering in that second count?
I believe that most of us felt that she was operating a vehicle under the influence of alcohol, and that played into it. However, to some individuals, there was reasonable doubt on the mechanism to which Mr. O'Keefe actually succumbed and died. So I think that had a play as well. So those were some of the factors that were being discussed in that jury room.
So it's 12-0, 12-0, not guilty on 1 and 3. Let's go to count 2. What was, by the time you finished, after all these notes and the deliberations, what was the split, and how many, and what exactly was each faction voting for?
It kept changing. At one point in time, it was split 50-50. And so 50-50 initially, 6-6, then started to, based on debate and deliberation, it became clear, and we all kind of agreed that she was operating, or anybody for that matter, if they were operating a vehicle during that time frame and with all that alcohol, was probably under the influence of alcohol and should not be operating a vehicle. Then it changed to between 8-4 versus 9-3. And ultimately, I don't think we came up to a final conclusion on a final tally as a direct result of it continued to be stuck, and it was very clear that some people were under the mindset and the belief that she was not guilty. And so at that point, those notes were continuously passed, ultimately with the final note. And
I've heard different things at different points about what the guilty votes were for. Was it for the top count was it for the top charge in count 2, or any lesser included charge within that second count?
So it was, I'm sorry, can you clarify the question? I just want to make sure I'm answering it.
Sure, absolutely. So within count 2, where you have 6, then 8, then 9 people believing she's guilty, was it guilty of the charge in count 2 or a lesser included charge within count 2?
It was a lesser included charge within count 2 at one point.
Okay, we've gone through the deliberations. When we come back, Ronnie, what I want to do is go through some of the moments and some of the evidence in the case and get your perspective on all of it. This is really eye-opening. Ronnie Estanislao is going to stay with us the whole hour as we continue taking you inside the jury room in the Karen Reed trial. We'll do that, plus, coming up next hour.
Tonight on Vinnie Politan Investigates, the murder of 13-year-old Madeline Soto. Newly released images from the home, from the car, and of Stephen Stearns are giving us new insight into the case. Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
This stuff about playing a race card is preposterous.
The racial division was so great that people saw the facts differently.
Trial and Error. Why did O.J. win? New episode Sunday night, 8 Eastern and Pacific, only on Court TV.
After the fire department arrived and they sort of take over resuscitative efforts with regard to Mr. O'Keefe, what, if any, observations did you make of Ms. Reed and what she was doing or saying at that point?
Ms. Reed was visibly upset. She kept saying, this is all my fault, this is my fault, I did this.
As I was ventilating, I was able to ask, did anybody see anything? What happened? And there was one individual that replied several times, I hit him.
you indicated that the defendant said, "I hit him." Is that correct?
Yes.
That's something that she said once or more than once?
3 times. I hit him, I hit him, I hit him. Earlier, it was could I, did I. When she spoke to the paramedic, it was crystal clear. I hit him.
And there were more witnesses that said the same thing, and prosecutors argued it was a confession by Karen Reed that she struck John O'Keefe with her car. What did the jury think of that? Still with me, a juror from the first Karen Reed trial, Ronald Estanislao. So, Ronnie, did you listen to those witnesses, and did you hear a confession from Karen Reed, and do you believe that she confessed to striking John O'Keefe with her SUV?
I did not hear that. I mean, to me, it was not a confession. I believe in a moment when somebody's stressed, they may be saying things. We kind of the group found it interesting, and I found it interesting that that was what everybody kind of remembered, when usually in the heat of the moment and the stress of the moment when taking care of a patient, you focus on taking care of the patient and not necessarily what others are saying in the background. So we looked at it, but we moved on from it.
Interesting. Let me just follow up on that for a second. Do you believe that they were coached into saying that or misremembered? What do you think?
I believe that at the time, certain people may say things. I don't know, honestly, and speaking for myself, I could say that I did not put any merit in it. And there may be some sort of coaching or kind of rehearsal, knowing full well that you're going to be testifying. But again, in the legal system, I don't know how that actually works out in the end to the jury, but the jury obviously some individuals can take it as such, and some people can actually look at it as something differently or dismiss it.
Interesting. I mean, are you a paramedic, so you would have some experience in dealing with folks?
Yes.
Oh, so that's what I love, when jurors bring their own life experience in and can mix through and parse through some of the things and apply a little common sense to all of it. That's awesome. I want you to take a listen to the 2 medical examiners now, because that testified in this case about the injuries and what they signified. Let's take a listen.
The cause of death was due to blunt impact injuries of the head and hypothermia. When we have a potential vehicle, clearly we look at the height, because one of the things that we do in most or all pedestrian or people struck by a motor vehicle is look at the legs.
Would that be consistent with injuries that you observed in other cases of a pedestrian collision?
They're not the classic pedestrian injuries that we observe, no.
Are every injuries from a pedestrian collision the same?
No.
Are those injuries consistent with an animal attack?
Are they consistent with what?
An animal attack.
I would say they are, yes. I'm not 100% sure about this, but my initial reaction when I saw this photograph was that it was probably an animal.
Based on your extensive training and experience, what is your opinion regarding whether those injuries are consistent with being struck, with an individual being struck by a vehicle?
If you mean struck in that part of the body, on the arm, like
yes.
Directly, I would say no, it doesn't look like that at all.
Okay, Ronnie, let me ask you. You had those medical experts, you had the trooper who testified about the pirouette as described by Alan Jackson, you had the experts that were brought in by the defense as well, called by the defense. Did any of this evidence convince you one way or the other about whether or not John O'Keefe was struck by a car, that the injuries were consistent with being struck by a car?
This is where we debated for hours, And so some of us believe that there was injuries there, and the injuries were after Karen had dropped him off, and therefore those two individuals were there at that location, and ultimately John O'Keefe was dead in the front lawn. And so for some of us, it was conclusive evidence that she was guilty. For some of us, though, the injuries were not consistent with a pedestrian struck per se. It wasn't the standard. I understand that there may be different mechanisms, but there was not enough evidence or testimony given on how it could be not the standard pedestrian struck with extremity injuries. And so it seemed inconsistent. So for some of us, it solidified that essentially it was not collision with the motor vehicle that ultimately caused the blunt force trauma to his head.
And which camp were you in? Did you believe it was the car, or did you believe it was something else?
I believe that it may be something else. So it was not, it created reasonable doubt as to what they were presenting as the evidence in the testimony.
What did you think of the cuts on the arm of John O'Keefe? Did you believe it could have come from a dog?
Again, it wasn't conclusive. To me, it wasn't conclusive whether it was an animal or just abrasions due to glass or scraping against metal. But there was no conclusive evidence on where it actually originated from and where those scrapes or abrasions, how did they get there per se.
Okay, let's talk about the tail light of the SUV. It was broken. It's clear it was broken. I'll start with your perspective. How do you believe the tail light was broken? What caused that?
Some sort of impact, clearly, that caused the breakage of the tail light. I think in terms of testimony, we would have preferred that the Dighton police officer who testified clearly indicated a little bit more information on whether the broken taillight was consistent to when he first saw it at the location at the Reed's residence versus, and then it was towed. And then also it would have been nice to have some sort of testimony from the tow truck driver who transported it to the Canton Police Department, because in that sense, we would be able, whenever you move a vehicle, usually you take pictures or note any damage. So I would imagine that that tow truck driver probably would have had some sort of information, unless he did not do due diligence and actually write down any kind of damage on the car prior to moving it to the Canton Police Department.
So I want to show you what we call the Sally Port video, which is when the SUV is brought into the Sally Port. It was presented in two different ways, right? On the left, the prosecutors brought it in that way, and it was inverted, and it was backwards. So left is right, right is left. So when you're looking at the right tail light in the exhibit presented to the jury by prosecutors, it's actually the left tail light. Did that bother you? Were you offended by the fact that the video presented by prosecutors actually inverted the video and made left right and right left, and they didn't tell you about it?
It was quite confusing, because when we actually looked at it, we said, oh, the tail light is intact. Versus when you look on the other side, there seems to be some sort of damage potentially. So it did kind of affect our thoughts, but ultimately we tried to look at the timeline, and if it was possible that there could have been some tampering with the vehicle prior to its arrival to the Sally Port, but we kind of dismissed that and moved on. Kind of looking at the overarching information that there was an injured individual who ultimately died on the front lawn. There was a motor vehicle with some sort of damage to it, and somebody who was operating the vehicle who was clearly indicated to be under the influence of alcohol.
So from your perspective, you moved on and didn't really determine one way or another if Trooper Proctor or anyone else tampered with that taillight?
We didn't feel like there was any tampering per se because of the fact that it didn't seem like there was the appropriate timeline to actually do some tampering and then get it to the lawn or the crime scene within the correct time frame.
Gotcha. Wow. What a great jury. Thoughtful, smart. Ronnie Estanislao is going to stay with us. We got you in lockdown for the hour, Ronnie. You can't go anywhere. Thanks so much. We're going to continue this conversation because there's more evidence and some more questions like, does Ronnie believe justice was served? That's a big part of the story in the Karen retrial, which was everything that has happened on social media, in the local community, and obviously at the courthouse. Let's bring back in our special guest tonight, a juror from the first Karen retrial, Ronnie Estanislao. Ronnie, did you guys have any idea, did you personally or other jurors have any idea about what was happening outside the courthouse? I mean, the dozens and dozens of people, many of them wearing pink, that were there day in and day out.
We did not allow them to distract us in any way, shape, or form from our charge and what we were responsible for doing, which was to listen to the witnesses, the testimony, and the evidence, and deliberate and ultimately try to come to a conclusion. So we did not allow that to distract us in any way, shape, or form.
But you guys had an idea that there were a bunch of folks there, and they're very passionate.
We could hear them at times, obviously, but again, we didn't allow it to distract us from our job at hand.
Fantastic. Let me ask you a couple of big questions here, and we discussed that. Sure. You all came to a 12-0 not guilty on counts 1 and 3, which is enormous. You invested a lot of time in all of this. Who is at fault for this confusion from your perspective? And this confusion that you guys did your job, you came to a verdict on 2 of the 3 counts, yet somehow, some way, it all slips through the cracks. Like, who's at fault, do you believe?
I think we were responsible as the jury because we did not ask the right questions. I think there's always the justice system. We're not professional jurors, and we don't know the justice system like lawyers would know and those who are in the system. So some instruction would have been great, but I think moving forward and knowing this, I think people need to know that it's okay to ask questions. There's nothing wrong with asking a question. And I don't know if we were just intimidated as a jury to be asking and not feel stupid, for lack of a better term, to ask the question that could we have looked at the charges independently of each other. So I think we unfortunately failed the system to ask that, but it could also be a combination of the system not giving enough instructions. Again, like, we are not professional jurors. This is something that people don't usually do and don't know exactly the rules. So shame on us for not asking the question, and shame on the system for not could be clearly indicating what can be done and can't be done.
Well, let me just say, Ronnie, no shame on any of you. No shame on any of you. You get called down there, and you are 12 who invested all that time. You are the 12 who didn't come up with some excuse why you couldn't do it. It's your civic duty. It's shame on the system, 1,000%. I'll answer that one for you. And I think you're just being nice. And let me ask you this, though. What is the takeaway from you, having gone through all of this? Do you feel that there's an injustice now going forward in this case? Do you feel disappointed? Do you feel angry? Do you feel confused? What is it that you're taking away, having gone through all this and seeing the way that it sort of ended up?
I think disappointment in terms of not having to provide closure to the families and to everyone. I think we were tasked with a duty, and we didn't provide any closure at the end. I feel like it is going to be another extra resource when, if we had just clear direction at that time, we would be able to make a decision on 2 of those counts, and therefore this might not be a conversation that we may be having. So unfortunately, it is what it is, and I understand also why they do not or have not approached us to look at what went wrong, because in terms of now looking back at it, we've been out too long to know or investigate further on our own, and that would have tainted the evidence and ultimately the deliberation process of the vote. That's why deliberation's very specific, and that's when the first time we're supposed to look at the notes and the evidence and debate amongst ourselves and not with others. So I can see how that's ultimately where we are. I just hope that in the future, there is now hopefully direction, a little bit more direction and clear direction, so that it can be looked at as individual charges. And I'll be interested to see what the results are, but it may actually remain the same in terms of the 3 charges, right? I think it
looks that way. They've gone to federal court, so it could change. A federal judge could step in and have some curiosity. Let me play something for you, because all those folks in pink, this was one of the big issues for them initially when this case was being investigated and Karen Reed was being charged. It was about a Google search that was done by a witness named Jennifer McCabe. Let's take a listen.
You see this first search that says "Hostel to dying cold"?
I do.
What's that time?
You've got the, it's right over at 2:27.
AM or PM?
AM.
Ms. McCabe, you made that search at 2:27 AM because you knew that John O'Keefe was outside in your sister's lawn dying in the cold, didn't you?
Absolutely not. I did not make that search at that time, no.
You realized the next morning, after John was discovered, after 6 AM, that you had an incriminating search on your phone, didn't you?
Absolutely not.
To cover your tracks, you searched it again in order to overwrite the original search at 2:27, correct?
Again, absolutely not.
Okay, Ronnie, your thoughts about the Google search?
I wish we had more testimony in terms of how it actually acts. So an expert to say, when you do a Google search at 2 o'clock in the morning, it's there, and even if you search it again at another time, it's supposed to always be there, and it's part of the history. If there was some sort of other expert who kind of would talk about that, it would have been great for clarification purposes. But again, not enough conclusive evidence for some of the jury to convict or not convict.
Let me play something else for you. Here's Alan Jackson cross-examining the lead investigator from the state police. I know you know who I'm talking about, Trooper Proctor.
Your assessment, personal assessment, that Karen Reed had struck this officer with a car, gave you license to call her a
It was my emotions had gotten the best of me.
And you called her a whack job. Gave you license to call her that too.
Yes.
Gave you license to say to your friends, oh, no. She's right?
That's what I wrote.
Gave you license to say that she's a
Again, another disgusting comment.
You get to talk about her leaky balloon knot, right?
Objection.
Okay. Ronnie, do you think Karen Reed was treated fairly by Trooper Proctor in leading this investigation?
His behavior was not very professional, and so his testimony was treated as such by some of us because of that damaging information. That being said, he was not the, we looked at the evidence as a whole, not necessarily just that one piece, but definitely unprofessional and unbecoming for somebody who is in law enforcement and in a position of power.
Okay, we only have a little bit of time here. What do you think happened?
I honestly do not know. I know that ultimately there was some sort of blunt force trauma sustained by Mr. O'Keefe. He ended up on the lawn and he succumbed to his injuries because of the cold and hypothermia. What brought him there, I do not know. Other than Karen Reed and John O'Keefe came to 34 Fairview, and then from there, what happened and what transpired, I do not know, other than John O'Keefe died and Karen was able to drive home and then ultimately came back in the morning.
Yep.
So again,
that's reasonable
I don't
doubt.
have clear vision.
Yeah, that's reasonable doubt.
Yep.
Ronald Estanislao, amazing. Thank you so much. Thank you for your service, and thank you for shedding a lot of light on what has really become a very divisive and confusing case. Ronald Estanislao from the Karen Reed jury. When we come back, something else you need to know tonight.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
An Iowa man is found unconscious after crashing his car. He asked police to check on his girlfriend, recalling flashes of violence. Now he's on trial for her brutal murder.
The Visions of Violence murder trial, weekday mornings on Court TV.
Time to reveal something else you need to know tonight. Taking a look at the big board. Guilty on all counts. That's Marshella Chidester from the birthday party murder trial. Convicted of killing 8-year-old Alana Phillips and her 4-year-old brother, Zane Phillips. Her sentencing will be scheduled for May 15th. Those charges include second-degree murder. An emotional day in court, but justice was served. Please take a look at your screens. We have a missing child who needs your help tonight. This is Amaya Dillman. Amaya missing out of Maricopa, Arizona, just 16 years old. If you see Amaya, please pick up the phone, make a call, make a difference. You can call 911, 1-800-THE-LOST, or you can call the Maricopa Police Department in Arizona. We've got that number up on the screen for you right now. Let's see if we can get Amaya to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.